Good morning. Good morning.
Morning.
Good morning.
Okay, I think let me see where I'm on. Yep. I'll take the register and then we can do our recap and move on to unit 12. I see A signs. Yes. Let me know if you can hear me, please. My thing is in our canal.
Yes, ma'am, I can hear you.
Okay. Okay, you heard what I just said?
Sans, yeah.
Okay. Next person, please.
Here, Sans is here.
Okay. Next person.
Francis is here. Good morning.
Morning. That's W. Francis.
Yes,
Yeah.
ma'am.
Uh-huh. All right, anyone? Who else?
Low, Leah Low here.
Okay, hello. Okay. And that's it? Okay. So last week we went over trust investments. And we understand the powers of investment in the trust instrument. Who has the power of investment?
Trustees.
Uh-huh. Anyone else? Anyone else has the power of investment?
Agents appointed by the trustees.
Okay, who else? Do I remember the power holder?
Yes, the power holder.
What about the power holder? What y'all remember about that? What happens with the power holder?
Would that be in the instance where if the trustee wants to make an investment, they have to be, it has to be authorized by the power holder, or the power holder could actually request that the trustee makes an investment on behalf of the trust?
Right, and what section deals with this power holder of the trustee act? There's a section that y'all would have learned earlier that inserts this power holder provision in the trustee act. It talks about this power holder. Who could be a power holder?
Section 20, no, sorry, I guess a protector could be a power holder.
Uh-huh, and who else?
Would that be somewhat the same as someone who's appointed?
Settler? What about the settler?
I
Y'all
guess.
remember section 81A? Y'all did anything with section 81A?
Not that I remember.
Not to my knowledge.
Pardon me?
No.
Y'all had a section on power holders, no?
Not that I remember specifically.
Okay, I'm gonna look and see if you all had anything on it. Because you all should have something ready, inserted that section 81A, because you're talking about powers of investment now, and what section 13 provides for the trustee. Yeah, you all had power holder. You all had power holders. What section 13 provides for the
That's
trustee?
protection for the trustee where they've actually acted on the instructions of the power holder, or if they decided not to act because they didn't get instructions from the power holder.
Right, so this power holder, usually power holders, they've, the settler usually uses this now to be able to direct, the investments in the trust. So that was a advantage that they used, in inserting that. You all would have dealt with power holder since unit 2, parties to a trust. You would have dealt with a power holder then. So make a note, just so you all would refresh yourself with that. What Spite and Gun tells us. What the case of Spite and Gun tells us.
To act as a prudent man with the same way you would act with your own personal assets.
All right, and what that defines for a trust.
Standard of care.
Yes, excellent. What Cowan and Scarlet gives us. What the case of Cowan and Scarlet gives us.
To act in the best interest of the beneficiaries, both present and future.
When we doing what?
When we are investing.
Excellent. So when the trustee is investing, his primary duty is, before deciding how and when to invest the trust, is to act for the benefit of the beneficiaries in the in the best interest of the trust. What type of beneficiaries he's acting for?
Sorry, say again.
Which beneficiaries is he acting for when he's acting in the best interest of the benefit of the beneficiary?
Would that be all?
Those, what Cowan say? Both what?
Present and future.
Yes, both
Oh.
present and future beneficiaries. Now, what section 5 of the Trustees Act tells the trustee?
That's the section that gives like guidance or instructions on how investments should be
And
made.
so, and what they did with the standard of care.
They made it more detailed, I guess.
Right, they narrowed it and they called it a what? A prudent who?
A prudent investor.
Yes. Excellent. So now we have section 6 of the Trustee Act. What helps the trustee in doing what?
That's a section that speaks to
Appoint.
being able to appoint persons.
Investors.
Right, so now they could delegate their powers to certain persons, provided they do what?
Successfully turn over the rights to do so.
Provided they, what they supposed to do when they sending out their, delegating their powers.
confirm the legitimacy of whoever is going to be acting in that capacity. And then also they have to make sure they follow up regularly so they can know what's going on.
Right, right. So that's important that they follow up, right? And once they've done this, what happens? They have some protection under Section 6, right?
Yes,
Because they're protected from any loss suffered by the trust from their
Yeah.
reliance on these persons, right?
yes.
Okay, y'all seem a little shaky on our last unit. It's shaky, or y'all just not wake up yet?
Yeah, not wake up yet.
Okay, but y'all good on it.
Yes, ma'am.
Recording
Okay.
in progress.
All right, so
All
let's
right, so
move on to Unit 12. I know this may be a different unit for some. But this is beneficiaries. Y'all can hear me?
I
Yes,
can hear
ma'am.
you.
Okay, I see a Janice. Who's that? Sorry.
Sorry, I had to switch. I didn't realize you weren't hearing me. Janice
Okay.
Stubbs. So I had to switch my
What's the last name?
Stubbs.
Stubbs. Okay, no problem. Okay, after completing this unit, we should understand beneficiaries' interest in a trust, understand the trustees' duties to beneficiaries, understand the rights of beneficiaries in relation to the administration of the trust. Okay, who will begin for us? They'll go right up to beneficiaries' rights.
I can start.
Thank you.
A trustee has a duty to act in the best interest of the beneficiaries of a trust. Failure to act in the best interest of the beneficiaries would result in a potential breach of trust action against the trustees by the beneficiaries. A trustee must treat all beneficiaries fairly and impartially and must balance the interests of the income and the capital beneficiaries of a trust to ensure that all needs of the beneficiaries are met efficiently and effectively in the administration of the trust. Additionally, trustees must not put their personal interests in conflict with their duties to the beneficiaries or before the interests of the beneficiaries, as it would be a breach of their fiduciary duty. Calvin versus Scarlet, 1985. In Calvin versus Scarlet, it was decided that the duty of the trustee towards their beneficiaries is paramount. They must, of course, obey the law, but subject to that, they must put interests of the beneficiaries first. When the purpose of the trust is to provide financial benefits for the beneficiaries, as is usually the case, the best interests of the beneficiaries are normally their best financial interests. Beneficiaries have a vested interest in the trust property as equitable owners. Their equitable interest must be preserved and protected by the trustees in the effective and responsible administration of the trust.
Okay, so the trustee's duty, first of all, is to act in the best interest of the trust. We know that. And his failure to act will be in breach. He could be potentially in breach of the trust. More importantly, he must treat all beneficiaries fairly and impartially and must balance the interests of both the income and capital to ensure all the needs of the beneficiaries are met effectively and efficiently. What we say about the income and the capital beneficiaries when we decide in where we're gonna charge something from or expense something from or provide some income to one of these beneficiaries, what we said about that? It is the trustees what?
Discretion.
Yeah, he can use his discretion as to where he's gonna charge something, because what we use as an example when we were discussing this,
Maintenance.
right? We're talking about the maintenance of a house where the beneficiary may be living in and who beneficiary may be living in the house.
Capital.
No, we were talking about who owns the house.
Oh,
The
Who owns
trust,
the house?
that the capital beneficiary will own the
Right,
house.
so,
The income beneficiary will be living in the house.
right, so he may be living in the house. And there's regular wear and tear, and we were trying to decide who should actually pay for this. So it will be now for the trustee to decide, you know, something, it's not fair. The capital beneficiary, some of this is for the income, so we may just split it, right? Or we may just charge it to one. So it's still up to the trustee to use his discretion, right? Now, the trustees cannot allow their personal interest to conflict with their duties to the beneficiaries or before the interest of the beneficiaries, right? Scarlet says that, and they give a definition stating that the trustees' duties towards the beneficiaries are paramount. So they must obey the law, but subject to that, they must put the interest of the beneficiaries first. And when we talk about these financial benefits, well, they're supposed to be providing finances for the beneficiaries. What happens in that case? We put in what first? Their interest is usually what type of interest then? When we have to provide them with financing? Is it their moral interest,
Moral interest.
financial interest, which interest?
financial interest.
Right, so when we provide in finances, the best interest, what we're thinking of at all times is their financial interest. So now we said beneficiaries usually have a vested interest in the trust property as equitable owners, because who's the legal owner?
The trust,
The
The
trustee.
trustees. Yeah, the trustee is the legal owner of the trust property and the beneficiaries are equitable owners. So they have a vested interest. And as such, those interests must be protected and preserved by the trustees in the effective and responsible administration of the trust. When we talk about protection and preservation, we talked about that last chapter. When we talked about that, we were talking about investments, right? Remember, we talked about protecting and preserving, so can we make speculative investments when we're supposed to be providing for both income and capital, and these people need money over a long period of time? Can we make short-term speculative investments that are high risk to the trust?
no,
No.
So it's
No,
always so
should-
depending on the circumstances, the surrounding circumstances, the needs. Would we say we are gonna consider when we making investments? What are we gonna consider? Section 5 of the Trustee Act guides us.
To be
What it
prudent.
says. We supposed to do what?
we have to, I guess we have to think about long-term, how it's gonna affect the trust. If it's
Right.
suitable to the trust.
Right. In the
Balance
context of the
return.
whole trust property, right?
Yes,
So what else?
Exercise reasonable care,
Right, and what else we have to do?
caution, and skill that an ordinary person would have.
Right, but what else we have to do? That's one point. What is y'all got
Prudent
the
investor.
suitability? Pardon me?
Okay, no, I was just talking about a prudent investor would.
We had exercise reasonable care. We should have regard to the suitability of the investment in the context of the trust property. And what else we need to do?
Diversification.
Yes, we have to diversify. We have to have all those things in mind when we are investing. Any questions? Okay. So somebody could read beneficiaries' rights up to under section 82, right to the bottom of the page. please.
As the beneficiary, he has certain rights under law in relation to the trust and trustees administration. Both statutory and common law require that the beneficiary has the right to information regarding the trust except information that may be prohibited by law. The trustee has a duty to give the beneficiaries information regarding the state of affairs of the trust. In the case of O'Rourke v. Derbyshire, 1920, AC 581, Lord Ranbury stated that a beneficiary has a right of access to the documents which he desires to inspect upon what he has been called, in the judgments in this case, a proprietary right. The beneficiary is entitled to see all trust documents because they are documents and because he is a beneficiary. They are, in this sense, his own. However, a beneficiary is not entitled to see all documents belonging to the trust, as minutes of meetings and correspondence between trustees are not permitted to be seen by the beneficiaries, particularly those which indicate the exercise the trustees' discretionary powers in the administration of the trust. For the purposes of trust law, these documents do not form part of trust property for which beneficiaries have an equitable interest and a proprietary right. Accounts and other documents relating to the trust. In Re Londonderry's settlement 1965, the trustees of the settlement had a power exercisable with the consent of certain appointers to appoint shares of capital amongst the class of beneficiaries. A member of the class was dissatisfied with the share appointed to her and was of the view that she was entitled to inspect the agenda, minutes of trustees, meetings, and correspondence of the trustees. The court held that the beneficiary is not entitled to inspect the documents. In accordance with the law established in Re Londonderry's settlement, a beneficiary has to show the following in order to be entitled to inspect any document in possession of the trustees. They were documents in possession of the trustees as trustees. They contained information about the trust, which the beneficiaries were entitled to know. They had a proprietary interest in the documents. Section 83 of the Trustee Act 1998 gives beneficiaries of Bahamian Trust the right to information under certain specified conditions and in certain specified circumstances. One such right is the right to information regarding the production and receipt of trust accounts, as when requested by the beneficiaries. Paris v. Green. Beneficiaries have a right to inspect trust accounts and demand information and explanations on them. Under common law, beneficiaries are not entitled to demand copies of trust accounts unless they are prepared to pay for them. Ree Watson. Under Section 83 of the Trustees Act, this discretion in a discretionary trust.
Okay, so beneficiaries' rights. We know Section 83 is the statutory law. And the common law, we have several cases that dictate or demonstrate how their rights to information may be had. So O'Rourke v. Derbyshire says they have a proprietary right to the trust property. Now, as much as they have that right, they only have a right to certain documents. They're not entitled to see the minutes of the meetings, correspondences between trustees and beneficiaries or the like, or trustees and probably outside parties who may be giving instructions. And they do this in particular because you may have aggrieved beneficiaries or beneficiaries who feel they may not be getting an equal share. So London Dairy settlement demonstrates how a beneficiary may challenge the trustee's discretion in making distributions. So the court ruled that the beneficiary can see the title deeds, accounts, and other documents relating to the trust, but they don't have a right to see the trustees' minutes and how they would have deliberated in making their decisions. So in order for them to inspect the documents, the documents should be documents that were in possession of the trustees as trustees, contain information about the trust that the beneficiaries were entitled to know, and the fact that the beneficiary has a proprietary interest in the documents. So section 83, we spoke about this before, where the beneficiaries have certain rights to information. They have right to information under certain specified conditions. One such right is the production and receipt of trust accounts when they are requested, and past Green that gives us guidance. The beneficiaries under the common law can inspect the trust accounts and demand information and explanation on them. So we said something about the trustee keeping these documents. How long we say they should keep these documents?
5 years.
A minimum of 5 years. So under common law, the beneficiaries are not entitled to demand copies of trust accounts unless they are.
Paying for them.
Yes, you remember we talked about this before, so it's Watson, who tells us they need to have some funds to pay for these when they demand in these trust accounts. So they can't demand the trustees' minutes or the correspondence between trustees, and those in particular, the ones that deal with the exercise or non-exercise of the discretion in a discretionary trust. So we have the common law position, which is, what is the common law position? Where we get the common law position from?
From cases that have
Yes.
existed.
Right, and what are our cases in the common law position for the right of information? Right to information. What cases we can use?
Settlement,
First versus Green.
First v. Green,
Uh-huh,
Barry Watson,
uh-huh,
For O'Rourke, Derbyshire. Okay.
right. And our main one,
Cowan, Scarville, 1985.
right, and what's the one would use an example? London Dairies, eh?
Yeah.
And what is the statutory law in the Bahamas?
Section 83.
Excellent, so we know section 83. Any questions on that section? On beneficiaries' rights to information? Excellent.
One
Okay,
question.
Go
Wouldn't it
ahead.
be required to remember all of these cases?
no, it's just helpful. I mean, it's easier for you to tell a story than it is for you to try to memorize. So if you could associate these cases, it'll cause you to remember the principle quicker. So we know what Ree Watson is. What Ree Watson tells us.
They can request the information, however, they would have to pay for it.
Right, so they cannot demand trust accounts unless they are prepared to pay for them. So that, sometimes you may not remember things, but if a case comes up, you may say, oh, Ree Watson say something, and then you could put the principle derived from the case and it could help you to answer. So London Dairy settlements dealt with what? Someone challenging what?
To get the trustee minutes.
Right, they wanted to see how the trustee made a decision. And so now from that case that they cannot do what?
They would not have access to that information.
Right, so they're prohibited from seeing trustees' minutes and correspondence, but they can demand, they can see other documents as set out in Pass v. Green. Would Pass v. Green tell us?
Trustees have to be able to provide trust account information when the beneficiaries request.
Yes, right. So now, as much as they have that, Pass v. Green said they have to provide this. They should be able to provide it. And what O'Rourke v. Derbyshire tells us, they have a what interest in trust, in the trust property or documents. What they have? What type of interest they have? What type?
Proprietary right.
They have a proprietary right on an what? What type of interest?
Um,
Taxable?
Right, equitable interest and proprietary right. So you see how it just, it will, if you just have to get those points and then you can put some meat on the bones once you have the bone. So the bone is the case itself, eh? Then from that, you can remember the story that was told when you were dealing with that particular unit. Is that helpful? Or not really? Not really?
Again, a little bit.
I feel like I know it.
I mean, because we still have to, in order for you to associate them with answering our questions, we still have to kind of remember the case and then remember what the case is about. So
Okay.
we still have to remember everything.
Because I feel like I remember the principles, but not the actual
Okay.
specific case.
Okay, because I mean, I thought we remember Watson, because that was our little, we had a quite lively discussion from, I think someone was saying, well, why should they be paying? And we talk about the bank statements and all that. Remember
Right.
that?
Right.
Right, so I remember the principle of it, but I didn't
Right.
remember what the
Remember.
case name was.
Okay. So see, something will come back. Either the case will help you or you'll remember the principle from it. So
But I guess
that's-
the question is, do we need to, in answering questions, we need to actually say Watson?
No, see, what I'm saying to you is when you put Watson, that means you have that much more understanding and knowledge of the topic.
Okay.
So as with anything, you would get, your points will look different than somebody who just says, there's some proprietary right, because then I have nothing to stand on, because as much as we know they have common law and statutory, if you now tell me the statutory law is section 83 and someone just said they have a statutory right, and you said they have a statutory right under section 83, who gets more points?
Okay.
You see? Because that means you understand the topic that much better and you could just quote off the sections that much easier. So your concept is a little deeper in your understanding, yes?
Okay.
So what is your suggestion on how we retain these
Now, the
cases?
only thing is, you see, because everybody's different, but I mean, the sections are good to, like, just to put them together. It always is good because it helps you in your own understanding, and referring to the sections, I mean, that usually gives me a trigger. So it triggers what I'm supposed to be answering. So usually, I mean, my understanding of it is based on the sections. So I'll say, oh no, section 5 says, no, you have to do this, or section 4 says this. Like, okay, the trustees can rely on advisors' advice, and they can be protected under law. Section 6 gives them protection. What section 24 of the Trustee Acts provide?
No idea.
No.
If I tell you something, I'll be lying.
I
We
agree.
talk about this insurance. Remember, we talk about insurance?
Oh,
They-
yeah, yeah.
They can insure themselves, however, they can't insure for what?
breach
So
of
the
trust.
breach of trust.
Yeah, so your section 24, what section 83 says?
See, but this my problem. When you ask a question, because I read the book, I could remember, like I could remember what I studied, right?
Okay.
But when you start to tie those cases or the legislation behind it, honestly, I get a little bit frazzled.
Right, so that's what it is. So now that's how your learning gets a little deeper, because now your understanding is not just based on the book itself, but you actually understand it outside of just reading the book. So you don't just memorize, you understand it. So it's a difference in you memorizing and you actually understanding. So you should read it with an understanding and not try to remember, because your memory fails. But when you see someone tells you gossip and you could repeat it verbatim, you don't need to study that. So that's how you have to take your lessons, like somebody gossiping to you. So that's how I usually do my studies. I don't study as if I can't remember. I don't remember nothing. But if you tell me a story, I could sit there and regurgitate everything you tell me. I accept that. And that's how children used to learn earlier, right? You used to tell them stories and they grasp from the storytelling. Instead of you trying to memorize, you have to put it in a story format, and it helps you better with your understanding and your concepts, because then you could tie back more or less. So you see how we talking about the power holder? You should already tie that back to say, oh, power holder was set out, and the power holder could be the settler, and what's the purpose of them wanting to be a power holder? So you have to look at what this trust concept is all about. This trust concept is in order for the settler to provide succession planning for himself and his family. It provides him, in some instances, he can still live. Because why I want to set up a trust if I'm a rich person? Why do I need to set up a trust? What's the purpose of me setting up a trust? So you have to look at what is it behind it. Why would I set up a trust? What you gather from a trustee on a trust? What do you gather from a settler settling his assets and passing it over to a total stranger? Why would he do that?
He may have more professional background on how to manage it better. He may want to increase his wealth before he passes away. He may want to make sure that before he passes away, he distribute evenly to who he wanted to go to, so that it wouldn't be left up for probate after he passes. So people don't have to fight over it. A probate usually takes longer than if you would have a trust.
Right.
You have professional people that are skilled to manage the trust better, or to give better advice on how to distribute or how to go about I guess making sure that everybody gets what they deserve.
Right. And sometimes I may be a rich person, a wealthy person, and I may still be in the business world, and I'm subject to liabilities, eh? So what I want to do, protect my what?
Protect my assets. Okay.
Yes, so this an asset, we could be protecting our asset protection trust. And I still want to be able to benefit from my trust whilst I'm living. So I'm a lifetime beneficiary, eh? I get the income from this. I may not get, I'm not, this isn't for me, this is for my children. They're gonna be the capital beneficiaries, but during my life, I'm an income beneficiary, so I get whilst I'm living. And what that protects me from, I'm a doctor I'm a neurosurgeon. What happens why you think I want to protect my assets?
In case you're being sued.
Because if somebody sue you, you don't want them to take all of your belongings.
Right, so now, I work hard, I'm able to certain lifestyle. But one slip of the scalpel and now what happens? Everything goes up in smoke, eh? So I protecting my assets and I still protecting my children's future. So when you look at the concept behind it, then you will now start to put certain things in place. Why we putting all these rules in place? Why we creating these outlets for these investments? Because what happens with me as a settler, I have now turned over my trust to a stranger, more or less. He's now responsible to do as he sees fit. What does he sees fit? Would we calling that in this instance? Is
Discretion.
what? Yes, it's discretion. So you see how when we talk this story, if we were talking it in our own terms, this fella do as he see fit. But when we talking in the terms of professional language as a trustee, we call it a
Discretion.
discretion. See? So when you start to put it in terms of, this isn't so difficult. It's just that I need to now see it for what it is, and now put it in terms of how they're setting it out in the forensic language of a trust. Then you would see it's not so difficult. But it's just for you to get that. You have to start to think differently, because see, you looking at it probably as it being a lot of information, but when you see what the concept is behind the trust and why would they create all these provisions? Why in this instance, they said you could demand trust accounts, but Watson tells you you got to pay for it. Why do you think they put that in there?
Discourage.
It is.
No, what happened is something like this has happened before. Any case would come up, something happened before. So that means that the trustee was subject to the beneficiaries demanding trust accounts. So suppose I have 30, 40 beneficiaries and all of them decide we want to provide us with these trust accounts. That's an administrative function, eh?
Yeah.
And the trustee is in business. So their business is to provide this, and the trustees are paid a certain amount a year. Is it fair that the trustees now have a demand from a beneficiary for accounts, and it's now charged to the trust and all the beneficiaries have to share in that cost? Who should pay
No,
for me
because
getting a
then
trust
that
account?
means that you're depleting the
Yes.
trust,
Yeah,
and only
so
one is asking for these accounts.
right, so now in your own right thinking mind, you will say, why should my sister have to pay for what my brother is asking for? So that's how you have to look at it to see what that's how you look at it, as from a story point of view. You getting what I'm saying now to you?
Yes, I do.
Okay, so I'm just trying to let you see it from a different perspective, because I think you're looking at it too narrow, and you need to widen the view and make it a little bit more to a lay person and trying to look at it just from the book perspective, because the book is a bit abstract, but when you put the meat on it, then it makes a little bit more sense to you. Okay, I hope that was helpful. Or did we
It was.
confuse? Okay.
Yes, it was helpful.
Okay, so we have however, who's gonna read however up to the first additionally, the trustee may refuse, and then the last person will take us from additionally beneficiaries to the end. So who can help us with however the trustee's duty?
I'll go.
Thank you.
However, the trustee's duty to disclose information and the beneficiary's right to trust information are the subject of the decision in the case of Vandam Skip versus Rosewood Trust Limited, 2003, 2AC 709, the Smith's case. In the Smith's case, Mr. Vandam Skip Smith sought disclosure of accounts and information in relation to two trusts set up by his father, who had died intestate. Rosewood Trustee Limited was the trustee of the two relevant trusts, having assumed that office from Lauren House Trust Limited, the original trustee. Mr. Smith had a discretionary interest under the settlement and sought disclosure in his capacity as a beneficiary, as well as in his capacity as administrator of his father's estate. The trustee argued that Skip was not entitled to disclosure of the trust documents because he did not have a propriety interest under the trust, being only a mere object of a power. Also, the trust argued, had the father been the settler under the trust, which had been executed by Pacoret Limited as settler, the nominee of Mr. Smith, The court held that the beneficiaries' rights to information was not only reliant upon the trustee's fiduciary duty to keep them informed regarding the provisions and administration of the trust generally, but also upon the court's inherent jurisdiction to ensure that the trust is administered in accordance with the terms of the trust, and if necessary, act on behalf of the beneficiaries to achieve this objective. Therefore, the classification of a document as a trust document, the beneficiaries' interests and their ownership rights to trust assets were not the primary considerations in determining the beneficiaries' rights to information. Based on the Smith's decision, a document will be ordered to be disclosed if it would be conducive to the proper administration of the trust. It does not matter whether the document is classified as a trust document. Requests from beneficiaries must be reviewed on a case-by-case basis, and trustees should be guided by the purpose for the beneficiary's request and the interests of the beneficiary. Following the decision in the Smith's case, a trustee should take into consideration the following information when making a decision to disclose trust information to beneficiaries. A, the nature of the request, B, the reasons for the request, C, the information being requested, and D, the sensitive nature of the information being requested. Next paragraph.
Yes, please.
Okay. Additionally, the trustee may refuse to accede to a beneficiary's request for information if there are legal grounds to do so. An example, information is privileged. The information is confidential as per one beneficiary to another beneficiary. The interest in the trust is a remote or contingent one. The information may be prejudicial or adverse to the trust. Example, challenge to the validity of the trust, and the disclosure of information may be too costly to the trust.
Okay, so we have the trustee's duty to disclose information and their right to trust information as set out in the Smith v. Rosewood case. So the trustees, the beneficiary's right to information was not only relying on the fiduciary duty of the trust to keep them informed, but on the court's inherent jurisdiction to ensure that the trust is administered in accordance with the terms of the trust and to act on behalf of the beneficiaries to achieve this objective. So in that Smith case, the beneficiary, what was the difference with him? What happened with this beneficiary in Smith? What was so different about him when he was demanding information? He was only subject to a what? You can hear me?
Yes, ma'am.
Okay.
Yes.
He was only subject to being what?
He had a object of power since he was administrator of the estate.
Right. So as that, what now must the trustee look at when he's making a decision as to whether he should disclose the information? He's supposed to look at the nature of the request, the reason why they're requesting it, what is the information that is being requested, and the sensitive information, the nature of the information being requested. And he may now refuse to provide the information to the beneficiary. In this case, did he refuse to provide information?
Yes, he did.
Yes, that's why they would have take him to court, eh?
Yeah.
And so he can refuse to provide information where the information is privileged, where it's confidential as to from one beneficiary to another, or where the interest is a remote or contingent one. In this instance, what happened? It is a what type of interest?
Proprietary interest.
this fellow, Smith, what type of interest he had in the trust? What his interest was? He was an object of a power, right? He was a beneficiary who was an object of a power only, right?
Yeah,
Right.
So his interest may be one that is so remote, it may never happen, or it's contingent on something else happening before he can be considered, right? So in this instance, the trustee say, I am not providing it because your interest is so remote or contingent upon something that may never happen. So I don't have to provide it. So they could refuse to provide it on that, or it may be prejudicial or adverse to the trust. It may cause someone to challenge the validity of the trust, and the disclosure of the information may be too costly to the trust. So the trustee can refuse to provide information where there are legal grounds to do so. And those legal grounds are set out. That is privilege, confidentiality, interest being too remote or contingent, or it may be prejudicial or adverse to the trust, or it may be a bit too costly to disclose that information. So Smith case guides us in the right to information and how the trustees will now provide the information only if they can refuse to provide it, or they can do what? They can go to the court and get what? The court's what?
You mean the trustee or the beneficiary going to
The
the court?
court. When we go to the court will say now what? They can make a decision as to what? What the
Yes, they-
courts may say.
they might have,
Yeah,
by
they-
telling you you have to provide it.
Yeah, because it's conducive to what?
Right information.
So they will order the trustee to provide it if it is conducive to the proper administration of the trust. But of course, all of these requests are taken on a what basis?
Case by case.
Yes, so it's based on who's asking and what is the situation surrounding. So when we taking it on a case by case basis, what are we considering? The nature of the request, the reason for the request, the information being requested, and the sensitive nature of the information being requested. So it's on a case by case basis as per the beneficiary. And then we would make those, we'd see what's the nature of your request. What is the reason you're asking this? What information you're actually requesting? And how sensitive is this information that you're requesting? And is it something that we want to put out there? Because at the end of the day, it may be something that will be too costly to the trust. It may challenge the trust validity. It may be confidential to one beneficiary and not to you. So you shouldn't have the information. It may be privileged information. That's something that should not be out there. Or your interest is too remote or contingent. I don't even need to provide you with this. Any questions? Okay. So who's taking us home? The last person.
That'll be me.
Thank you kindly.
Okay. Additionally, beneficiaries have the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal action regarding the administration of trust and their duties and obligations to them. It should be noted that Section 23 of the Trustee Act does allow trustees.
Let's fix that to 24, please. It should be 24.
Okay.
Section 24.
Section 24 of the Trustee Act does allow trustees to insure themselves from the trust fund for legal actions brought against them by beneficiaries, except for breach of trust. Beneficiaries also have the right to terminate a trust through the use of the rule in Saunders versus Vautier. In the circumstance where a trustee holds property in a trust for one beneficiary and there are no contrary terms in the trust instrument, that beneficiary, if he is sui juris of the requisite mental and legal capacity, has the right to request that the legal title to the property be transferred to him, for which the trustee is obliged to do. Both the legal and equitable interest in the property will be vested in the sole beneficiary, and the trust will effectively terminate.
So
Where
what's the
there-
rule in Saunders v. Vaudier?
That the trust can be terminated through legal title transfer to the beneficiary if they are of requisite mental and legal capacity.
Okay, so once they're sui juris and they are entitled to, absolutely entitled, then they can
They can request.
terminate the trust, right?
Yeah.
Right.
Remember, you all did that earlier, right?
Yes,
You all did Saunders v. Vaudier,
yes, we did.
right? So once the rule is, once they are sui juris and absolutely entitled, they can,
Terminate the trust.
right? So y'all would have dealt with that when it was on termination of a trust, right?
Yes.
Yes.
The section you would have dealt with the rule in Saunders v. Vaudier. Okay, go ahead.
Where there is more than one beneficiary, in order for the rule in Saunders versus Vautier to apply, all of the beneficiaries must be sui juris and properly ascertained and complete as a group and beneficially entitled to the trust property. The rule in Saunders Vautier cannot apply in the case of unborn, unascertained, or unascertainable beneficiaries.
Okay, and what case dealt with a group and ascertaining the group?
I can't tell you the case, but I think it was I can't tell you the name of the case, but I think it was a case where a company was trying to determine who the beneficiaries are.
And
When
then
they-
what kind, and what the company, what these beneficiaries and what they were to the company?
Family members of staff or former staff.
So it was, the company was given to their who? Employees,
Yes,
right? And you remember that was McPhail and Dalton?
now that you say the name, yes.
Yes, McPhail and Dalton deal with ascertaining the beneficiaries as a group. And it have to be, you have to be ascertained, meaning they should be able to do what?
Determine if you're a part of the group or not,
Yes,
clearly.
yes.
Right.
So for the rule in Saunders and Vaudier to apply when there's a group, it must be not only sui juris, and they must be all absolutely entitled, but they must be able to be
Identify.
Ascertained and complete.
as a group, yes. Where can it not apply? Where there's unborn, unascertained, or unascertainable beneficiaries. So when you put, what is an example of an unascertainable beneficiary? They would have had an example for you. Give me an example where I could put something and it just won't make sense.
I guess if you leave it open to say, like in that case, employees and all of their heirs.
All the heirs. Can we possibly ascertain all the heirs of the employees' families? That's too big a group, right?
Right,
So it's not workable, they call it, right?
right. So I
So
guess
then-
if somebody wants to prevent their trust from ever being terminated in that way, they just would include a
To
group
be
that.
more specific. When it's unascertainable, what also McPhail dealt with? Certainty of what? Which one of the certainties that dealt with? Subject matter, objects, or
The certainty of, no object.
what
I
the
don't
three
re-
certainties? What are the three certainties?
certainty of object, certainty of subject matter, and power.
Certainty of words or intention.
Okay, so the words must be
Power.
unequivocal. So it must have intention, it must be object. What is the object? What is the object?
To state, if I remember correctly, to state exactly what the trust property is.
No, the subject matter is the trust property. The object is the beneficiaries.
Beneficiaries.
Right,
Must be
so
clearly
well,
defined.
what McPhail and Dalton would have, why the trust would have failed, and if in McPhail and Dalton, what would have happened?
The
If
beneficiaries were
One.
not clearly
it could
defined.
have, it would have failed because of uncertainty of object.
Okay.
If it's too big or the class is not workable, then the trust fails because we can't ascertain the beneficiaries. So you see how we tie in back our information which you would have learned earlier?
Yes, ma'am.
Okay. Okay, let's continue.
Sure. However, the rights of beneficiaries in relation to the rule in Saunders-Vautier may be restricted depending upon the circumstances. While the rule in Saunders-Vautier enables beneficiaries to end a trust in certain specified conditions, a settlor may expressly exclude this rule by placing an express clause within the trust that the beneficiaries shall not be able to end the trust by collectively requesting the legal title to trust property.
So in order for the settler to avoid this happening in the future, where he knows, you know, this trust can end based on this beneficiary becoming absolutely entitled, I want you to put another clause in here stating that they cannot terminate this trust based on that rule or based on the fact that they would have been sui juris absolutely entitled and they are able to be ascertained. So we'll put an express clause in there that the beneficiary shall not be able to end the trust by collectively requesting the legal title to the trust property. When they collectively request the legal title, what they've done?
Terminate the trust.
Yeah, they terminate it because now the legal title transfers to them, eh?
Right.
They're no longer equitable owners, they're now the legal owners. Go ahead.
Additionally, trustees must control the administration and management of the trust. Beneficiaries, whilst they may have an equitable interest in trust property, are not entitled to dictate to the trustees how they should exercise the powers and discretions contained in the trust instrument. Reed Brockbank, 1948. This common law principle allows the trust to run smoothly, free of any interference from the beneficiaries, particularly those who may seek to advance their own interests at the expense of the other beneficiaries and possibly wield some inappropriate influence over the trustees who may not be mindful of their legal and fiduciary duties to the trust and the beneficiaries generally.
Because the trustees are supposed to use their discretion. So if they are acting under the inappropriate influence of some beneficiaries to the detriment of others, what happens? They are now what?
Not in control of the trust.
So who's under what we will consider them?
Puppets or nominees?
Yes, yes. So now we may now say this trust is a
Sham.
excellent. So you see how we all tie in this bar good now, you all getting the story together. Yes?
Yes, well.
Okay, let's answer our questions. Any questions before we go to our questions?
Sorry, guys. So I didn't hear if my answer was correct.
Which one? What you just said?
You
Where you
asked-
said Sham?
Uh-huh.
Yes, you were correct. That's well, I thought I was telling you. So who was answering? I just tell you all you're getting the story right now.
There was a few of us answered.
Not right after.
Okay. Okay, so failure to act in the best interest of the beneficiaries would result in a potential blank action for the trust against the trustees by the beneficiaries. Where we'll find that answer.
The first paragraph on page 91,
And what that is?
breach of trust action.
Okay, breach of trust. Beneficiaries have a trustee must treat all beneficiaries blank and blank. Where we'll find that answer?
Page 91 again,
Page 91.
first paragraph.
And what is that?
Fairly and impartially.
Okay. Number 3, beneficiaries have a vested interest in the trust property as blank owners. Where we'll find that?
Equitable owners, page 91, right before beneficiaries' rights.
Okay. Both statutory and common law require that the beneficiary has the blank regarding the trust, except information that may be prohibited by law. Where we'll find that?
'91 again.
Mm-hmm. And what it says?
Right to information.
Excellent. Number 5, a beneficiary is not entitled to see all documents belonging to the trust as blank and blank are not permitted to be seen by the beneficiaries, particularly those which indicate the exercise the trustee's discretionary powers in the administration of the trust. Where we'll find that answer?
Page 92.
And what is it?
It's minutes of the meetings and correspondence between trustees.
Excellent. Number 6, an important reason for this prohibition is that to allow beneficiaries to have access to such documents, blank to the exercise of the trustee's discretion. Where we find that answer?
Also on page 92,
And what is that?
to beneficiaries have access to such documents may create a challenge.
To the exercise of the trustees. Okay. Number 7, blank of the Trustee Act 1998 gives beneficiaries of Bahamian Trust the right to information under certain specified conditions and in certain specified circumstances.
Section 83, sorry.
83.
Excellent. Where there is more than one beneficiary, in order for the rule in Saunders v. 48 to apply, all of the beneficiaries must be blank and blank as a group and beneficiary entitled to the trust property. We will find that answer.
On page 94,
94. And what's the answer?
sui jury and
Yes.
properly ascertained and complete as a group.
Excellent. While the rule in Saunders v. Vaudier enables beneficiaries to end a trust in certain specified conditions, a settler may expressly exclude this rule by blank within the trust that the beneficiary shall not be able to end the trust by collectively requesting the legal title to trust property. Where we'll find that?
Page 94.
And what is it?
Placing an express clause.
Express clause, okay? Beneficiaries, whilst they may have an equitable interest in trust property, are not entitled to blank to trustees how they should exercise the powers and discretions contained in the trust instrument. So we'll find that.
On page 94 as well, they're not entitled to dictate to trustees.
Okay. So we've done all our questions. Any questions? No?
No, ma'am.
Okay. So let's go over our recap. Beneficiaries' interests in the trust are based on what are the beneficiaries' interests in the trust? It could be,
Equitable interest, you mean?
yes, the beneficiary interest in the trust is equitable. And the trustee's duties to the beneficiaries are,
They have to act in the best interest of the beneficiaries.
and what Cowan and Cargill say, what Cowan and Scarlet say, the duty of the trustee towards the beneficiary is
Paramount.
paramount. In addition to them obeying the law, they must do what?
Put the interest of the beneficiaries first.
And what is the interest of the beneficiaries in the case where they are to provide for financial benefit?
Their financial interest of are the
Excellent.
primary interest.
Yes, financial interest. What are the rights of the beneficiaries in relation to the administration of the trust?
They have a right to information except the information that's not allowed by law, like the minutes and correspondence between trustees.
So what the statutory law says, what guides us for their right to information in the Bahamian context?
Section 83 of the Act.
Yes, and what section 83 says, they have right to information except,
Minutes.
Trust document.
and why wouldn't they have that? What case tells us what could happen?
Is it the
Rewatch.
London Dairy settlement?
Would London Dairy tell you?
They might bring a case against the trustees based on information they may see about the discretion used by the trustees, but if they think it's unfair, they may question the actual administration of the trust.
So what they have to do now to get information?
They have to pay for it.
Right, and then what London Dairy tell us? In order for you to inspect documents of the trust, what has to happen?
They have to prove that they're entitled to it.
And how they'll approve it? There are 3 points.
If they were documents in possession of the trustees as trustees,
Mm-hmm.
and they contain information about the trust which the beneficiaries were entitled to know,
Uh-huh,
they had a propriety interest in the documents.
excellent. And what case talks about propriety interest of the beneficiaries? Proprietary right, that is. Which
London
case?
Dairy,
The one before that, who talks about it? That sound like an Irish case.
Or the Derbyshire.
Derbyshire.
Yes, O'Rourke and Derbyshire, they talked about the proprietary right. London Dairy talked about when the beneficiaries have access, what should be considered and how they can prove they have certain access or they're entitled to inspect the documents. What Smith case talks about? Smith v. Rosewood, what they deal with?
Trustee disclosing information and what the rights the beneficiaries have to getting that information.
So Smith talks about the beneficiaries' right to information is not reliant only on the trustees' fiduciary duty to keep them informed, but also on the court's inherent jurisdiction to ensure that the trust is properly administered in accordance with its terms and
Wow.
to act in for the beneficiaries, to act in the best interest of all the beneficiaries to achieve this objective. So when they are considering providing information, what the court says, they can consider,
Nature of the request, reasons for the request, what's being requested, and I guess the details.
if
Of the
it's any sensitive information,
The
right?
sensitive
So,
nature, yes.
can the trustees refuse to accede to a request
Yes.
based on?
If it's legal, I know one point is if it's legal.
Mhm,
Confidential,
mhm,
Based on the detriment that it would have by giving that information.
right,
If the interest is on a contingent basis,
so if the beneficiary's interest is one that is so remote or contingent on something, they may refuse to accede to request, and whether it'll be too costly to disclose that information, yes?
mhm.
yeah,
So Sanders and Baudier will apply in which case?
can
Right to terminate.
confirm
Right.
the. I guess that would apply when you're trying to confirm if they have an actual interest.
Right, so where they, in this instance, they may have what? Where there's a sole beneficiary, they can have both legal and equitable interest.
Mhm.
And that's when Sanders and Baudier will apply, they will now terminate the trust. However, what can happen in order to avoid that? What the settler can ask the trustee to do?
Put an express clause.
Express clause to ensure that this doesn't happen. What the trustee must do now in administering the trust, where the beneficiaries now try to dictate, is that right?
No.
No,
What they should do, avoid that, because
Yeah.
what happens? This beneficiary can do what? Exercise what type of influence?
I guess it could be unfair to be in their own personal interest.
Right, so it's inappropriate over the trustees to the detriment of the other beneficiaries, because it's only for that beneficiary in particular to now benefit. And we can now consider that if you only acting as a puppeteer or as a puppet to a puppeteer who's now your beneficiary, this can cause the trust to terminate for being a, yeah. Okay, so we must be of beneficiaries down to science. We only have one little small chapter to go and be done. You all understand it so far?
Yes, ma'am.
yeah.
Excellent. Okay, so God's willing, next week we will continue with breach of trust, and that'll be a wrap.
Okay.
Okay, any questions? Everybody's clear?
Yes, ma'am.
I think
Okay,
so.
all enjoy the rest of your weekend and be safe.
Thank you.
Take
You
care.
as well.
Bye.
Bye,
Bye.
everybody.